In our last video we discussed previously asked questions of CRPC. Now, let's start with the next important question. And the question is, consider the following statements. Bailable offense within the meaning of Criminal Procedure Code means 1. An offense which is enumerated as bailable in the first schedule. 2. An offense which is made bailable by any other law for the time being in force. 3. All other offenses as stated in criminal law. Which of the statements given above are correct? A. 1, 2 and 3. B. 2 and 3. C. 1 and 2 only. D. 1 and 3 only. Now, what will be the correct answer? According to the section 2. Subsection A. Bailable offense is an offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force. So statement 1 and 2 are correct. But third is incorrect. Thus our correct option is C. Now move to the next question. And question is, which one of the following statements does not come under the definition of complaint under section 2D of the Criminal Procedure Code? Options are A. Complaint is an oral or a written allegation. B. It is to be made only to the magistrate. C. It is related to some person known or unknown who has committed an offense. D. Police report made after investigation which discloses the commission of a cognizable offense. This question need more attention because it's not about why. It's about why not. As we know in section 2. Subsection D. Complaint is defined. Let's see the definition of complaint. Complaint means any allegation made orally or in writing to a magistrate, with a view to his taking action under this code, that some person, whether known or unknown, has committed an offense, but does not include a police report. This means, opinion D is correct. Let's move to the next question, and question is, inquiry under Criminal Procedure Code is conducted by A. Magistrate only. B. Police officer. C. Sessions court. D. Magistrate or court. First understand the term inquiry. Inquiry defined under section 2 subsection G. According to which inquiry means every inquiry, other than a trial, conducted under this code by a magistrate or court. So our correct answer is option D. By magistrate or court. Move to the next question. And next question is, inquiry is conducted by a magistrate with a view to A. Find out a prima facie case. B. Convict the accused. C. Authorize remand of the accused. D. Release the accused under section 436. The correct answer of this question is option A. To find out a prima facie case. Next question is,
the next question is, when a complaint is presented to a magistrate and the magistrate proceeds to examine the complainant and the witnesses, the magistrate, A. is conducting investigation. B. is conducting inquiry. C. is conducting trial. D. is conducting both. B and C. Our correct answer for this question will be option number B, because in case of complaint, if magistrate follow procedures to examine complainant and witnesses, the procedure will be conduct the inquiry according to the section 2, subsection D in which complaint is defined, and subsection G in which inquiry is defined. Let's move to the next question.
The next question is, investigation under the Code of Criminal Procedure 1973 is conducted by A. the police only. B. both the police and the court. C. the court only. D. the police under the discretion of the Sessions Court or the High Court. This question is based on the section, and it is most important for any competitive exam. Let's find out the answer of this question. As according to the definition clause of CRPC, section 2H defines about investigation, in which it is stated that the investigation for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by a magistrate in this behalf. So our correct option for this question is option A, by the police officer. Let's move to the next question. And the question is,
the object of investigation is A. to arrest the accused. B. to punish the accused. C. to collect evidence against the accused. D. none of the above. As we see the definition of investigation in our previous question, our correct answer will be option C. Investigation is process to collect the evidence against the accused. Now, move to the next question, and the question is,
consider the following statements. Statement 1. Investigation is made by a police officer. Statement 2. The object of police investigation is to collect evidence. Statement 3. Investigation is a judicial proceeding. Statement 4. Investigation is not a judicial proceeding. Which of the statements given above are correct? A. Statement 1, 2 and 3. B. Statement 1, 2 and 4. C. Statement 2, 3 and 4. D. Statement 1, 3 and 4. Statement-based questions are very tricky. We must have to go through all statement very carefully. Because each statement in itself a question. Now try to understand statements one by one. Statement 1. Investigation is made by police officer. The statement is correct as according to the section 2H. Next statement. Talk about purpose of investigation. And the purpose is to collect the evidence. The statement is also correct. Next statement. Is investigation as judicial proceeding? This is wrong statement because inquiry is judicial proceeding. From here we can use option elimination method. Our statement 3 is wrong. Now check option in which statement 3 is not mentioned as correct statement. We get only option B. Now in this question if we have no idea about statement 4, we can easily go with option B. With 100% accuracy. These small tricks will help in exams if you have practiced many questions. Now move to the next statement. Which talk about, investigation is not a judicial proceeding. Yes, this is correct statement. So statement 1, though, and 4 are correct. Our correct option will be option B. Now move to the next question. And the question is,
which one of the following proceedings is known as judicial proceeding? A. Investigation. B. Inquiry and investigation. C. Inquiry and trial. D. Trial and investigation. Correct answer is option number C. Inquiry and trial comes under judicial proceeding. Trial is also judicial proceeding in which accused get conviction or acquittal. Move to the next question. And the question is, under section 2. L of CRPC, the non-cognizable offense means an offense in which a police officer has authority to arrest without warrant. B. A police officer has no authority to arrest without warrant. C. A police officer above the rank of Deputy SP has power to arrest without warrant. D. None of the above is correct. Correct answer is option number B. According to the section 2. L, it is defined that a non-cognizable offense means an offense for which a police officer has no authority to arrest without warrant. Option B is correct. Let's move to the next question. And the question is, in a non-cognizable case, the police has the authority A. To investigate and even arrest the accused without warrant. B. To investigate into the offense but cannot arrest the accused without warrant. C. Neither to investigate without order of the magistrate nor can arrest the accused without warrant. D. To arrest the accused without warrant but cannot investigate without orders of the magistrate. The correct answer is option number C. As we understand the process in previous question. I hope you enjoy this video. Please don't forget to subscribe and share. Thank you.